Good afternoon. My name is Paul DeBolt, and I'm the chair of Venable's Government Contracts Group. I'd like to thank you all for joining us this afternoon for our webinar entitled COVID-19, What Government Contractors Need to Know, Legal Issues Arising from the Novel Coronavirus. Joining me on the panel today, I have a number of colleagues that have breadth of experience. Ron Jacobs is a partner in the regulatory group. Diz Lacaria is a partner in our government contracts group. Jen Przinski is a partner in the labor and employment group. Ann Garrison is counsel in our regulatory group, and Mary Gardner is a senior associate in our regulatory group. So the topics for today, we're going to have a short introduction, not that anybody needs one, to everything that's going on. We're going to move into special considerations for government contractors, and then we're also going to talk about some other business considerations. We'll talk a little bit about insurance, events issues, employment, and communication. So Ann is going to walk us through the background, but I think that before she does, I know we all appreciate how fluid the current situation is. We've done our best to try to assemble the best information we can about how government contractors should be dealing with these issues, but the slide deck that you put together at 8 in the morning wouldn't be the slide deck you would put together in the afternoon. I mean, we received notices from both the Virginia and Maryland governors that they're both issuing stay-at-home orders, which just came out this afternoon and are going to have an impact on your workforce. The other thing that occurred was that President Trump signed the CARES Act on Friday. Certainly our firm, like the number of other businesses and firms, are working through that and trying to figure out exactly what it means and how it's going to impact the government contracting community. But Ann, why don't you go ahead and just walk us through some of the background, please.
Happy to. Thanks, Paul. So this is unfortunately one of those slides that needs no real introduction because I think we're all incredibly familiar with COVID-19 and its various elements at this point as a novel coronavirus that's part of an ongoing worldwide pandemic. People can be contagious between 2 and 14 days after their infection without showing symptoms, and so it's spread very rapidly. And as a result, there's been an unprecedented response both around the world and in our country to try to mitigate the spread and impact of this disease. And so there have been government orders limiting movement, some leading to the shelter-in-place, stay-at-home orders. Non-essential businesses have been closed, and the effect on the economy following from that has been huge. And accordingly, every sector is responding, including the memorandum issued by OMB concerning federal contract performance in light of the current circumstances with COVID-19. So with that, Paul, I'll send it back to you.
Great, thank you. So the effect on government contractors has been dramatic. There have been a lot of questions that have been asked about what this means for their current work, what it means for contractors' future work. There's an impact on the availability of the customer. Any number of government agencies are working remotely these days. There's some inconsistency, at least there was up until probably the order that we're going to continue this safe distancing through the end of April about when agencies would reopen. We've heard from different clients that different agencies have decided that any future procurements are going to be put on hold for the foreseeable future. They're going to look at slowing down the review of some proposals that have been submitted, and they're really just going to focus on the work that actually needs to get done, which can have impacts on all of your businesses as you were looking at your capture strategy throughout the year and trying to figure out which proposals you were going to win and what revenue was going to look like. As I mentioned, there's restrictions on travel. The government's been encouraged to have industry days and debriefings virtually rather than having live meetings. There have been things that have been canceled, and there is a push to have more and more people work remotely, which presents a whole host of challenges to the extent that someone's a single parent, or you have one desk in your house and both spouses are trying to work from home, along with the child care challenges. The next thing we're going to talk about is we're going to move through the presentation and talk about some of the special considerations for government contractors. There was a memo issued about a little over a week ago by Office of Management and Budget. It was a memorandum to the heads of executive department and agencies regarding managing federal contract performance issues associated with COVID-19. We've referred to this as the OMB memo, and my colleague, Diz Lacaria, is going to walk us through that.
Thanks, Paul, and good afternoon, good morning, everyone. Thanks for joining us. As Paul mentioned, the federal government has issued a number of kind of proclamations and declarations and things, and one of the main avenues it's doing that is through OMB, the Office of Management and Budget. And on March 20 of this year, it issued this OMB memo, which pertains to government contractors. There's also some memos related to government grant recipients as well, if you're interested. But this particular memo was given to all executive departments, heads of all executive departments and agencies, giving them guidance on how to handle their workforce and the government contractor workforce in the immediate kind of crisis that we're dealing with. And it set forth a number of steps for government personnel to consider for both their workforce and the employee workforce in conformance with the CDC guidance. Next slide, Paul. So, not surprisingly, as many of us are already aware, the federal employees have been urged to work from home, and that obviously, as Paul mentioned, is kind of evolving daily as more and more states clamp down what's permitted. But the federal government needs to take a lead in this, and so it's having its workforce work from home, which is obviously creating a lot of problems for government contractors that are working on site. They can't get access to that site. And so the agencies have been instructed to be flexible in their administration of government contractors, and to the extent feasible, to allow them to also telework and give them the ability to work even though the facilities aren't open. Now, I mean, inevitably this is going to create disruptions, and the agencies have been asked to assess whether or not the skilled professionals or key personnel need to be kept in a mobile state for activities that the agency deems critical to national security or other priorities. So the idea being that the government contract workforce needs to be at a ready state. They can work from home, great, but if they need to be deployed somewhere in order to get the job done, that's also a possibility. OMB memo also talked about assessing whether contracts that pose capabilities for addressing impending requirements such as security, logistics, or other functions might need to be retooled for the pandemic response. In other words, changing the scope of a contract in order to deal with this current threat as opposed to the work they might be doing. So those are key things that government contractors need to keep in mind, is that government is really putting a lot of things on the table that wasn't previously, hasn't previously been the case for traditional government contractors. Next slide. Now, the agencies have also been encouraged to utilize the Stafford Act. With the Stafford Act comes a number of different benefits to federal contractors. It can change the threshold of the micro-purchase threshold, of the simplified acquisition threshold. It can change competition requirements. So these types of things allow agencies to get much needed supplies, resources, services into the field much quicker. And so we've been fielding calls for the past couple of weeks with traditional government contractors and non-traditional government contractors, all interested in seeing what they can do to help the fight against the coronavirus, whether it's supplies or services or new technologies. Really, the implementation or the declaration of a disaster in the Stafford Act opens up a lot of doors for government contractors and the government to be much more flexible. Next slide. So the OMB memo included a number of frequently asked questions and guidance for the agencies. And we'll walk through some of these points here. First of all, as I mentioned, the agencies are encouraging contracting parties to telework to the extent that's feasible. Now, that may require modifications to a contract. It may not, but something for government contractors to keep in mind is what flexibility under the contract is there for working from home as opposed to working from a government site. A lot of times folks have different rates working from home as opposed to working from a government site. Usually it's less expensive to work on a government site because there's government overhead and things. Now that overhead is being moved to everyone's home office. Whether those need to be negotiated or worked out will remain to be seen. They're also asking if telework is not possible to allow for flexibility with respect to the delivery and completion dates on government activity or contract requirements, contract deliverables. And then reminding also everybody that there's 3 FAR provisions right here in the slide, talks about excusable delays. Things like the coronavirus are absolutely captured. What we've seen in practice is actually the agencies are being very flexible, at least right now, with everything. We're finding that agencies are pretty understanding of the situation. Obviously, they're in the same boat in many cases. They're working from home. They're finding challenges working from home. Balancing work and life is a much different thing now. And so we're finding that the agencies have been pretty reasonable and understanding so far. Next slide. So then if the contractor cannot perform because of this situation, whether they can't get access to a SCIF, they can't get access to whatever it is that they previously had access to, the memo advises agencies to consider terminating the contract for convenience, essentially a no-cost termination to the contractor in order to, free up those resources to do something else. So that is something to keep an eye on. Obviously, termination for convenience is a far different thing than a termination for default, but very important to make sure that you're capturing your costs because you can get many of those costs can be recovered. So make sure you're capturing those costs in the event that a termination for convenience might ensue. The next one deals with requests for equitable adjustments. And this is where I think the rubber is really going to hit the road, right? Government contractors are going to be shifting from the workplace environment to a kind of the telework or home office or not. And what additional costs is that causing? And are those contractors going to be seeking equitable adjustments? These are supposed to be reviewed on a case-by-case basis. So absolutely something to keep in mind. The next bullet deals with whether continued or stopped, whether the work should be continued or stopped, kind of part and parcel with the termination for convenience. But again, a case-by-case assessment of whether it makes sense to continue that contract, to put a pause on that contract, or just to cancel or terminate that contract altogether. The last on this slide deals with things like industry days and other conferences and events. The government's obviously pushing for everything to be done virtually. Webinars are nothing new, but I know a lot of folks and organizations are having virtual happy hours and things like that. So the government is getting involved in that as well with the idea of virtual conferences and things along those lines. Next slide.
Yeah, before we go to the next slide,
yeah.
I wanted to bring up 2 other points about the memo. With regard to the termination for convenience, the memo instructs the government to do that in a way that doesn't negatively impact the contractor's performance rating. And we all know how important past performance is as you're trying to go after future work. So to the extent that you believe an assessment could impact that rating, this memo may be something that you want to use to try to shape your evaluation of your performance. And then with regard to the costs that you're going to be looking at, the memo also sets out the standard of review. And the standard you're going to be judged against is what would a prudent person do at the time the decision was made to incur these costs. And I don't know that there's any a lot of people that have been through this situation before, but to the extent that you make a decision, you want to document why it was reasonable at the time based on the information that you have, because that'll be very important when we start to see the audits that are going to come after we wake up from this nightmare. Go ahead. I'm sorry, Des.
No, I think those are great points, Paul. So in terms of some of the additional guidance, communication, it's one of the items that the OMB has recognized. And candidly, this is something that you always want to have, is very good communication with your contracting officer as well as your program office. You want to make sure that folks are all on the same page in terms of expectations with respect to delivery, the quality of the delivery, et cetera. And nothing is new with this except for the fact that it's going to be probably challenging. There's a lot of upheaval in society, and hopefully some of that dust will settle as people get more used to this new norm. But making sure that you're communicating and documenting those communications, I think, are going to be absolutely imperative. That way, when the auditors come in after the fact and decisions are second guessed, you have some kind of record to show that you were not making these decisions unilaterally, but rather had the government involvement in it. A couple other quick ones. SAM registrations are being pushed out 60 days. Candidly, as challenging as SAM has become over the past couple of years, this is not insignificant. And then also it emphasizes the use of FAR 18202, which is, again, that emergency response under the Stafford Act, where agencies can change the micro-purchase simplified acquisition threshold to allow for, to facilitate easier contracting. Next slide.
Yep.
So which, if any, of the company's contracts are suitable for telework? So again, the idea of moving everything to the home office and allowing agencies to make those determinations. You also want to have, again, made this point already, but whether or not the contract needs to be modified in that regard. And then some practical thoughts, though. Are government contractors capable of, moving their IT or their business to a telework environment? Do you have the IT infrastructure? Do you have the cybersecurity? Do you need new protections or infrastructure in that regard? I know my firm, Venable, when we moved, we spent about a couple weeks ago, testing how many people could be on the system at one point from a remote access. And, now we're operating with about 1,500 people, but we did some testing to make sure that the firm could operate. So making sure you have that IT and cybersecurity infrastructure, absolutely imperative, especially if you're a defense contractor. You have lots of cybersecurity obligations. Those are not going to go away just because of this situation. And so you need to make sure that you're taking appropriate precautions with respect to cybersecurity. Last bullet here, excusable delays provisions. Again, we referenced those FAR provisions and allowing you to get some additional time in the event or because of the coronavirus. Next slide. So with all of that kind of in the backdrop of this OMB memo, what are the considerations for government contractors? I touched on some of these, but, do you really need to push to get a change in scope on your contract? Changes in scope, you have delivery due dates in your contract. And so changing the delivery date on a contract is something that you generally need a contract modification for. So if you're pushing your dates out, you need to press your contracting officer to update your contract. Again, it may be forgiven, but I'd feel much better if my clients had their contracts cleaned as this thing went along, rather than dealing with an auditor a year from now, wondering why you weren't meeting certain delivery due dates, and wondering whether or not the government's entitled to some consideration. Now, there's lots of arguments you can make, but if you can do this along the way, keep good contract hygiene along the way, it saves, those challenges down the road when auditors come in looking behind with 20/20 hindsight and looking to claw back funds. The other thing is making sure, I mentioned this, but making sure that you're tracking the added costs of moving from whatever environment you were in to this telework environment. There's absolutely additional costs that may be incurred. if your contract's terminated for convenience, or even if you have a firm fixed price contract, but these are unforeseen circumstances that are adding costs, and you may be entitled to an equitable adjustment. So that is, should you file or consider an equitable adjustment? Well, I would argue that let's see how this all shakes out, see how much these added costs were. There's different things you can do to kind of get value with your customer, making sure your customer is aware that you kind of are not going to seek an equitable adjustment, that you want them to remember that going forward as a good partner, or do you need to seek an equitable adjustment? So these are all things to think about and to calculate in making that kind of business decision. We're talking about modifying the contract. The other thing is key personnel and making sure that the key personnel are able and capable to continue work, and would they need to move, or are they capable of moving to some kind of mobile state if they need to be sequestered or something like that in order to ensure contract performance, especially the defense stuff. You need to make sure that your key personnel are going to be available to do that. And then, keeping tabs on your subs. Again, you'll have excusable delay, and that can alleviate some of it. But if your subcontractors are not minding their P's and Q's, you're going to be, your work is going to be reflective of their performance. If they're delayed, then you're going to be delayed. If they're not, they don't have the cybersecurity infrastructure that's necessary to work from home, then that's going to impact your compliance. So not only making sure that your own organization can handle this, but you need to make sure that organizations that are working underneath you can do that as well. Because again, it all sounds reasonable today that this is the environment and people are accepting of it. But in a year or 2 years or 3 years, auditors will come in and take a close look at some of this stuff. And their 2020 hindsight will dictate whether or not they look to claw back funds, or even worse, feel that there is, such a material breach of a contract that it's, they could assert even a False Claims Act. We've seen it happen after Hurricane Katrina, after Hurricane Sandy, after Hurricane Harvey. We've seen it in many cases with natural disasters. And I don't believe that this situation is going to be much different when the auditors come down the pike. There's a lot of government money flowing. The auditors are going to come in and really take a hard look at some of this stuff. So we really want our clients to be mindful of that. With that, Paul, I'll turn it over back to you.
All right, thanks, Des. So we're going to continue to walk through some of the considerations for government contractors. That we've taken the clauses that are likely to be in your contracts and listed them there. But I think as you're analyzing the issues in the construct of your contract, there are really sort of like 3 things you need to keep thinking about. What did our contract obligate us to do, and by when? Is the company being asked to do something different, either doing different work, a reduction in work, or delaying work? And significantly, does the person in the government that is giving me this order have the authority to do it? Because you have to remember that in the government contracts context, the government's only bound by actual authority, wherein many times in the private context, somebody can be bound by apparent authority. And just as a general rule, the person that has the actual authority is a warranted contracting officer. The CORs, the COTARs, they have some authority, but it's limited. But when they're under pressure to get this work done because of the pandemic, there's an opportunity for them to push you in a direction to do work that you might not get compensated for. And then, the last thing you got to think about is, how am I going to get paid for this? There may be some things, as Diz said, that you do as a favor, trying to build a good relationship with the government, and you don't push it. But you want to put yourself in a position that if you need to push it, you can. And so you need to understand under the various clauses, how quickly do you need to notify the government of, the change or the delay or whatever you're faced with. So these next few slides, we've actually outlined the various clauses. I'm not going to, because of the time, I'm not going to go through them in excruciating detail, but we want to have this to you as a resource so you can understand how these clauses may apply to you, your contracts, and what your obligations are they're under. So we have the changes clause, which I know many of you are familiar with. We have a discussion of the concept of constructive change. That's something that is not necessarily directed by the government pursuant to the changes clause. It's just something that occurs over the course of performance because of direction that was given to you. There's a changes clause in the commercial terms and conditions that you need to be aware of. We have the suspension of work clause at 52-242-14, and this applies to fixed price construction or architect engineering contracts. We have the government delay of work clause at 52-242-17, and this is applicable to fixed price supply contracts. It's optional for service contracts. It's also optional when you have a fixed price supply contract that are for modified commercial items. So you need to, it may be there, it may not. For the stop work order provision, which, I won't be surprised if a lot of these aren't issued. I've heard that some of the agencies are sitting down with the contractors, going over an applicable PWS performance work statement and specifically identifying what work they're going to consider critical, and then authorizing the contractor to only to perform that work and then delaying the other efforts that is being performed under PWS. So if something does occur, and things are going to occur in this current circumstance, what should a contractor do? Well, we're going to just talk about that for the rest of the time on this section. I mean, the most important thing is to give notice to the government. Let them know what happened. Let them know when it happened. Let them know how it happened. You just need to raise your hand, and preferably you want to raise your hand in writing. The second most important thing, and Diz alluded to this, is to keep contemporaneous records of what happened. You want to write things down so that when the auditors do come or the government asks for proof of what you're alleging, you have contemporaneous documents that were written at the time the event occurred and document the cost. And then the last thing you want to do is you just want to segregate and track your costs. You need to make sure that you have good cost hygiene, that the codes are charged appropriately, the right people did the work, their timesheets reflect what work that they did. That's just going to put you in a much better position going forward. The next slide talks about where to start from a cost perspective. Again, notice is key, but you need to start the document and cost collection early. I think it's a good practice to create new project numbers to track the changed work. You want to make sure that you're using consistent accounting practices. And I think this list is relatively straightforward. And I think that one of the things that we all need to remember in this current environment is, even though the rules are changing, the priorities are changing for the government, information is changing rapidly, the basic fundamentals of government contracting still apply. And I think that the companies that are going to come out of this crisis in the best position from, having done work, being able to keep the work, not being accused, not having the government claw back money, or worse, accuse them of committing some sort of fraud, are going to be the companies that just continue to follow and apply the fundamentals. And I think that that's just going to be critical to ensuring your company's long-term success. So the next slide talks about the various areas that can be impacted by changes, deductions in work. And these are the areas that your finance people need to analyze. Is there additional work? Have we had to have larger crews? Overtime? Has there been idle time? Layoffs? How long did it take us to direct or correct the problem? what discussions have we had with the government? What coordination have we had to undertake with our subcontractors? Has there been a loss of efficiency? You know, has this impacted our labor rates? I mean, those are all areas that, as you're trying to figure out what the damages are, you need to work through. You know, the same thing, the other grouping is materials, subcontracts, and ODCs, other direct costs. And then the last category of cost is the indirect cost, because you may not be fully absorbing your overhead how you planned. You know, you could have a smaller cost pool to spread costs over. So you really do need to look at the various areas that could be impacted by a change or a delay in your contract. When you're working with your team, you want to get the source information because you want the best documentation available. And all this is going to be at the end of the day is evidence. It's going to be evidence that you give to your customer to show that these are the costs that we incurred, this is what we should be reimbursed. But it's also going to be the material that if an auditor comes in, that they're going to look at. And it's also going to be the material that if you can't get this issue resolved, and sometimes people don't get these issues resolved, and you have to go file a formal claim against the government and get involved, you know, going to the Court of Federal Claims or one of the boards of contract appeals, that you have this record that, you know, you can use to prove your case and maximize your recovery. And again, sometimes these things don't get resolved. You know, we've had clients that supported Hurricane Katrina. You know, they thought that the work they did should have been reimbursed. The government disagreed, and then you end up in litigation for 3 or 4 years. And the biggest challenge that those companies face that continue to get bogged down in litigation, it's a lack of contemporaneous documentation. So once we've identified what cost elements have been impacted, we've collected our material. I go backwards. We need to look at the supports. We need to look at the so we look at the source. I apologize. The cost element, we have the sources of supporting documentation, the various records. These are going to be the building blocks of your claim. And then once you get to the end, you're going to have to document your claim. It needs to be well organized. It needs to be realistic. You need to have the technical portion well written. You need to have the accounting part well written. You need to have the legal part well written and well organized so that the story makes sense to the customer, that they can follow the logic and see how you got from point A to B to C. It really is a story that you're telling. You want to tell the entitlement, why I'm entitled to this money, and you want to tell the quantum, how much they owe you. Okay, and you know, you want to start with your proposal and move forward. Graphics, charts, those things are all helpful. You want to make it digestible to the government customer and as simple for them to review as possible. And you want to try to minimize questions to the maximum extent that you can. I mean, candidly, you want to go in there with such a strong document that the government customer looks at and like, you're right, how can I not give you this money? That would be the ideal. This talks a little bit about why documentation is important. If you can't get it resolved as either a request for equitable adjustment or a claim at the contracting officer level, the courts are going to give greater weight to contemporaneous written documentation. You know, to the extent that it looks like you're moving toward litigation, you're going to want to retain your documents and make sure people aren't destroying documents. You can use written guidance. I think during these trying times, you also want to sensitize your employees to how they should be communicating. I can't tell you how many cases we've worked on where there's been a problem on a project and somebody is sending around an email joking about how we ended up where we did. And, you know, those things always come back to bite you. Like, you would not want an employee saying, oh, this claim had nothing to do with COVID-19. We bought in and lost our shirt. Now this is just an excuse to get well. I mean, and sometimes people will write those things. They're reckless. But people do need to be very sensitive to internal communications as you're trying to put together the the claim. The next thing we were going to move into was Public Law 85804. I was going to turn that back over to Diz.
Thanks, Paul. And so Public Law 85804 is a special law that's been out there for quite some time, but it's used sparingly. And essentially, it empowers the president to authorize agencies to take certain contract actions for national defense. And that last part is pretty important, the national defense part. Most notably, and the major reason why 85804 is used, is to grant indemnification for contractors when doing unusually hazardous or nuclear activities that create additional risk. Again, in the context of national defense. And so a number of folks have reached out with all kinds of ideas on how to combat coronavirus. And not surprisingly, because a lot of this stuff, I mean, the virus is obviously relatively new, and so all these technologies are relatively new. So those organizations, those companies, those clients are all concerned, you know, assuming the technology works, they have a great technology, but, you know, nothing is certain, and there always is room, even though it might have a 99% effectiveness rate, that's still 1%. And when we're talking about something as problematic as coronavirus, where it's literally shutting down the world economy, you know, that exposure is quite significant, and certainly would seem to fall within the concept of unusually hazardous. So let's talk a little bit about 85804, just to give you all a working knowledge of it. Next slide. So the FAR talks at length about 85804, and essentially the main thing is that whatever it is that's being sought to justify it, it needs to facilitate a national defense. And that really is going to boil down to whether or not combating coronavirus is in the spirit of national defense. That issue has, to my knowledge, not been decided yet, but I'd have to imagine that things that the CDC are doing, and certainly if you can get the Department of Defense to get a contract with the DoD, I think that would only bolster the argument of it being a national defense. Next slide. But the approval is not that simple. So it requires the approving authority to sign a memo, but the approving authority is actually the secretary or administrator of the agency that's letting the contract. And so it has to get all the way to the very top of an agency. Now, obviously, coronavirus has the attention, you know, the national attention. So presumably if there was a technology or some kind of service or technology that was combating it, that could move to the top of the agency relatively quickly. However, you got to understand there's probably quite a bit of noise at the top of these agencies at this point. So making sure that all the requests are getting there with the proper attention and information to get approval could be a challenging aspect. Next slide. And so then, well, actually, go ahead and skip to slide 32. So when you're submitting for 85804, it's not a simple request that, hey, we have something to combat coronavirus. Rather, it's a package of information that's going to have to get there. There's a number of different things that you need to provide in order to justify the granting of 85804. The first is identification of the hazardous, you know, the unusually hazardous or nuclear risk that you'd be facing, and indicating how the contractor is going to be exposed to it. I don't think that's a challenging thing to put together, but it's something that can't be forgotten in the process. Probably the more, not challenging, but the area where things are going to get more questioned, I would imagine, is going to relate to insurance. So the FAR provides that you need to provide information on your insurance coverage. And it needs to identify the risks. It needs to name your insurance companies. It needs to name the types of insurance you have, the dollar limits, the deductibles, exclusions, come back to that in a second, as well as applicable workers' comp. But the question is whether or not your device or technology can get insurance for this type of situation, or is it going to be excluded? Now, our understanding of 85804 and its past application has been that the government does not actually mandate that you have certain levels of insurance, but rather they want to know what insurance you are carrying. Okay, next slide. And then they're going to look at what other controlling or limiting factors relating to financial protection does a contractor have. In other words, they want to know, if something should happen, do you have insurance? Do you have financial wherewithal to address that to some degree before they go ahead and give you indemnity? Do they want to give you just a complete blanket indemnity, or do they want to somehow fashion that to where you still have some skin in the game to ensure that your feet are held to the fire in terms of what it is you're providing or trying to provide to the government? And then, they're going to also look into the contractor's insurance program, whether that's been approved and accepted by the government agency. So the way this functionally works is that the contracting officer has to write 85804 into your contract. So you have to have that conversation. But then it also requires the approval at the top of the agency. And, the way we've done this in the past is we work both ends. We work from the ground up and we work from the top down. So making sure that those two, there's often a number of layers in between the contracting officer and the top of an agency. So you need to make sure that those two departments are communicating in sync so this can move forward. It's a challenging thing to get overall, and it's not granted that often. However, I would anticipate 85804 being something that is extended in this context. In fact, we're working on that for a client as we speak. So there are a number of hoops to it, but it's obviously a significant benefit for contractors if they can obtain protection under 85804. But again, keep in mind, it needs to have that linkage to national defense. So with that, Paul, I'll turn it back to you.
Thanks. I mean, there is some historical precedent for the implementation of this. I think back in 2014, President Obama issued an executive order that covered government contractors that were supporting, I believe, USAID in Africa for the Ebola virus. So it's not unprecedented that this could happen, and there could be pressure that could come down from the administration. But, as you're negotiating contracts with the government for, let's say, drive-up testing or something like that, this could be another tool you have, in another arrow you have in your quiver to try to put your company in the best position possible to minimize risk. The next thing we're going to move on to are just some of the other business considerations that, businesses have, right, with regard to insurance and some other issues that could arise in the context of the pandemic. The first thing we're going to talk about is insurance coverage, and I was going to turn that over to Mary.
Thanks, Paul. So I'm sure that as Biz and Paul have already discussed, a lot of you are already grappling with some of the extra expenses, costs, and potential losses that we're seeing as a result of the coronavirus. And as harrowing as those losses and extra expenses can be, insurance attorneys like myself want you to know that we do believe that you may be able to get some recovery and some relief from accessing your insurance coverage that you've paid valuable premiums for. And those potentially applicable policies run the gamut from helping you deal with your current losses to helping at the end of what we hope will be a short period, helping you deal with some liabilities that you may see later on down the line. So in the short term, a lot of people may have business interruption policies or coverage through your property policy for business interruption. And this type of policy may provide you some coverage should you be seeing kind of delays or loss of income as a result of the coronavirus. On the back end, your commercial general liability may be a good place to look if you're seeing some kind of property damage, or if people who are not your employees are alleging that you in some way caused them bodily injury via exposure to coronavirus. Environmental policies are another interesting place that we'll talk about where you may be entitled to coverage, as well as employment practices liability and even your cyber policies. The one thing I will say as a caveat to all of this is that generally insurance policies are individually negotiated between a policyholder and the insurer. So there will be a lot of endorsements and amendments to these policies, and so any advice I give today is meant to be very generalized, and it's important that you actually review the specific language in your policy or ask an insurance coverage professional to do so. Next slide, please, Paul. So what are your first steps? If you have a great relationship with your insurance broker, I would say your first step should always be talk to your broker. Your broker is going to understand the broad outlines of your insurance coverage plan and exactly what kind of policies you have in place. And that person is going to be able to help you target the policies that are most likely to help you obtain coverage for both your lost income and your extra expenses. The other thing your broker can help you do is provide the notices that you have to provide to those policies. Once you've talked to your broker and you've gotten a good sense of what your insurance coverage portfolio looks like, the next thing to do is gather up all of those policies. So get the full copies of the policies. Again, your broker should have the entire complete copy of each of your policies. At that point, review your policies. There's some unique terms in your policy that you're going to want to look for. For one, does your policy have a communicable disease exclusion? That's something that we're seeing a lot of hang-ups on roadblocks to coverage with. So that's something I would pay specific attention to when you're reviewing your policies. And next step, as I've already alluded to, if you think there's even a small chance that you may get insurance coverage under your policy, I'd provide the notice. Again, that's something you can work with your broker to do, but it's really important to note that just because you tell your broker about an event does not mean that you've given notice to your insurance company. The notice to your insurance company is a step further and something that most brokers can help you do, but if not, it's a very simple letter, and the notice provision in your policy is going to lay out very expressly for you. Who do you send notice to, and what information does it have to be included in that notice? And in fact, most policies will tell you you have to send it via email. Here's the email address, or even old school, send it via facsimile. Here's our fax number. And something that Paul spent a good amount of time talking about today, documentation. The exact types of documentation that Paul was explaining you'll need to hold on to in order to present a claim to the government, those are the types of documentation that you should begin to compile as you think about your losses and extra expenses for an insurance policy, especially when you're looking at a first-party loss. So you, as the policyholder, have lost business income because of a delay in your supply chain. You're going to need to provide the actual documentation proof of that. So while you're doing that on the business side, you're going to be following a very same route on the insurance side. And then another thing that Paul said, be cognizant of your communications when it comes to insurance, as well as when it comes to your contract. Communications with your insurance broker are not privileged. So the last thing you want is to send a communication to your insurance broker saying, hi, so-and-so, it's a real shame. I just know we're not going to get coverage because of this communicable diseases exclusion, but let's give it a whirl anyway. Those conversations are best had over the phone. That said, I do recommend that you consult with coverage counsel should you think that your losses are potentially great and your policies are potentially complicated. You will have privilege with your insurance coverage counsel, and your insurance coverage counsel can help you deal with all of the issues that we just talked about. We can help you provide notice, we can help you organize your documentation, and we can help you advocate for your coverage. Paul, next slide, please. One of the major things that many of you may be looking at right now is concerns about lost income. And the primary place that we're seeing insurance coverage come for that lost income is from business interruption insurance. Now, this can be if your operations are entirely suspended, or it can just be a decrease in your output. So it's really important as you're tracking the flow of your business right now to really be thinking about whether you can see a cognizable decrease in the amount of income that you're bringing in. Because if you are and you think you can show that via documentation, that's something you may be able to get coverage for. And a lot of these policies include some really pertinent insurance coverage for the coronavirus outbreak. In fact, a number of these business interruption policies have civil authority coverage, and that can provide coverage for the types of government shutdowns we're seeing, such as in New York, where the majority of construction work was stopped as of this past Friday. So and then there's a subtype of business interruption coverage, and that's called contingent business interruption. And this can sometimes be in the form of a standalone insurance policy, or it could be an endorsement that's put at the end of your business interruption policy. And this coverage is going to help you if it's not you that's causing the loss or the decrease in your business operations, but someone else somewhere along your supply chain. So a supplier, a customer, a vendor, a subcontractor. If it's someone other than you that's the problem right now, this contingent business interruption coverage can be vitally important to ensure that you obtain the coverage that you need. Next slide, please, Paul. So I thought it would be good to spend a little bit of time talking about some of the potential roadblocks that you may face when you're looking at coverage under business interruption. I think that the biggest one you're going to see is a lot of business interruption policies require that your interruption losses be tied directly to some kind of physical injury or physical damage to your property. And I think this is going to be the big insurance issue that comes out of the COVID-19 business interruption and business delay loss. So an example of this would be an insurance company says, we will pay for the actual loss of business income you sustain due to the necessary suspension of your operations during the period of restoration. The suspension must be caused by direct physical loss of or damage to property at premises which are described in the declaration. Now, that sounds kind of ominous. So the real issue then becomes, what does physical loss or damage look like? What constitutes physical loss or damage? Do I have to put a sledgehammer through a wooden bench and break it into two pieces? Is that what it is? Because if it is, then these coronavirus losses are unlikely to count. Fortunately, though, this is not the first time in the history of insurance coverage that policyholders have sought loss or have sought coverage for business income loss as a result of damage that can't be seen by the naked eye. For instance, there was a case in 2014 in the District of New Jersey where there was a release of ammonia inside of a building. and that caused all of the construction on that building to shut down while they fixed the source of the leak. The building owner asked its insurance company for business interruption coverage for its loss of income. The insurance company said no. Well, they sued, and ultimately a court said that release of ammonia constituted direct physical loss because it physically transformed the air and rendered the property unusable. Now, that's not the only case of its kind. There are other cases out there that follow that same line, and so we do think that not all is lost, and that even if your business interruption policy contains this physical damage requirement, that there's case law out there that can support you, and that your coverage counsel can help you advocate and demonstrate why an insurer should consider the coronavirus in the air as evidence of physical damage. Next slide, please, Paul. Now, there are other types of insurance policies that may potentially help you with certain aspects of what you're dealing with when we're talking about coronavirus. So commercial general liability is one instance. Most policyholders out there will have some form of commercial general liability, and it generally provides coverage where a third party is either alleges they're injured by you, or they allege that their property was damaged by you. And in fact, bodily injury can sometimes include emotional distress. So that is one place that I would suggest that government contractors look to for coverage, with the caution being that a lot of these policies contain the communicable disease exclusion that we were talking about, which will be difficult to overcome in these policies. Another place is environmental insurance. I know that sounds kind of surprising, but environmental insurance, which we sometimes call pollution liability policies, can provide coverage for the expenses that you have to take to disinfect your work site, or the response costs you have to put in place to put someone at the door checking fevers and making sure that people are socially distancing if you don't telework. So although it's kind of an interesting place to think about coverage, when you're thinking about cleaning up the contamination of a coronavirus positive test, or when you're thinking about how you're remediating or mitigating the risk in your office place or on your work site, a pollution liability policy is a great place to look for coverage. And then another one is event cancellation. If you're putting on a large event sometime between now and June, I very strongly recommend that you look to see if you have event cancellation insurance. That insurance essentially will step in and cover your losses for either having to cancel your conference or relocate it to a different place, such as a virtual environment, or even to relocate it to a different time, such as just happened with the Olympics. Again, we are looking at the fact that a lot of these have exclusions for communicable disease, as well as the big kicker here, fear or panic as a result of a communicable disease. So you may see pushback from your insurance company if you're trying to cancel an event in June or July, that the cancellation is not due to the actual coronavirus, but instead is due to perceived fear and panic. There are ways to advocate for coverage effectively, and coverage counsel can help you create and compile necessary documentation to make an effective presentation for those later event cancellations should you need it. Next slide, please, Paul. Now, my colleague Jennifer is going to talk in some detail later about some of the employment issues that that may arise with the coronavirus. And so I will not dive into her topic as she's the expert here, but I will say that employment practices liability can provide you coverage should you have employees or former employees file claims against you for wrongful termination, discrimination, retaliation, any number of things that may come from the impact that coronavirus has on your employees. And then finally, as Biz noted earlier, there's a lot of cybersecurity risk that comes with allowing your employees to telework during this time period. In fact, I think there's already been at least 10 reported ransomware hacking campaigns that are preying on coronavirus fears. And it's possible that individual employees that are logging in remotely are logging in from a less secure network using less secure hardware than what you have available in your physical office space. And it's important to think about your cyber insurance, because your cyber insurance can help you should you have a data breach or should you inadvertently cause the release of someone else's personally identifiable information. And so it's important to think about what kind of coverage you may have in this kind of worst case scenario once this coronavirus has been contained and we're moving back to our normal lives. Next slide, please.
Right,
and I think at this point, thanks.
Go ahead. I think we're going to, the next thing we're going to talk about is events. And Ron Jacobs will be walking us through those slides. So go ahead and take it away, Ron.
Great. Thank you, Paul, and thanks, everyone. As Mary alluded to a minute ago with event cancellation insurance, there are a lot of issues that go into events. Now, at some level, it's kind of funny that I'm talking about events because a second ago, my phone just alerted to warn me of the shelter-in-place order that's now in place in Maryland. So the idea of going to an event may seem far off. But as Mary said, there's really the issue is, thinking ahead as to where this is going in the future. As these shelter-in-place orders are lifted, as we begin to travel more, the social distancing guidelines start to change, when do you host an event or attend an event? And the way I kind of look at these issues are that there are two kinds of events. There's our events that we might host, whether it's some kind of event to have government clients in or to kind of see what you have to offer or participate with others, or it's their event. It's someone else who's hosting an event and you want to send your employees there. And so we're not going to talk about specifically the employee issues because Jennifer will cover those in a minute, but those kind of comes into play. So the next slide, please, Paul, really shows that at the end of the day, there's really just a simple yes or no decision. Is the event going to happen or is the event not going to happen? And those are, there's a lot of thought process that has to go into there, but at the end of the day, you just need to think about what that looks like. So the next slide, please, Paul. And so the way I think about this, there's kind of three competing factors that you're going to think about. You're going to think about the risk to your employees, whether you're hosting an event or going to the event, whether at some level the fairness to the employee. Are you holding the employee back if there's an event that they need to go to at some point in time or that they want to attend? And then the importance of attending the event compared to not going to the event. So the next slide, please, Paul. So I've kind of gone through sort of a series of considerations to think through if you're going to cancel an event that you're going to hold. And again, this is, today as we sit here on the 30th of March, there's not a lot of events going on, but this is thinking ahead. What if we have a June event? What about a July event? When is it that we're going to be able to host these events? And if we cancel the event, what kind of financial obligations are we going to face, whether it be from cancellation of the contracts, our relationships with exhibitors or sponsors of the event? What kind of liability do we face? At one point in time, it wasn't clear, what kind of liability one would face from holding an event in a situation like this. Now, as things get more dire, it looks less and less like an appropriate response to hosting an event until things are all clear, particularly where there are issues with the virus as they recede into the background, hopefully. So we'll now move to the next slide, where we will start to talk about, in particular, the cancellation of the contract. I'm going to turn it over to my colleague, Anne, who will go through some of the things to look for in your contracts for these different kind of events, to think about how much it's going to cost if you cancel or postpone and how you have to go about doing that. Anne?
Thanks, Ron. So when you're looking at a contract for an upcoming event, and this matters for a contract that is probably either already or in the process of being canceled for the month of April, or, as Ron is saying, for events coming up in June and July when it's not clear if they'll be able to be held, whether you have any termination fees, or as they might be called in your contract, liquidated damages in place, or if you may be able to cancel your contract by act of force majeure. And so I want to run through those two kind of schemes of cancellations separately. First, in a cancellation without a force majeure, the contract terms will typically establish what the financial exposure is for cancellation. And because it can be hard to quantify, your contract may specify liquidated damages that are an agreed upon amount that will be the value of a breach. And an interesting thing about event contracts is typically they will set date targets leading up to the event where the amount of liquidated damages could increase. And so if you cancel 6 months out from your event, your cancellation fees are lower. If you cancel 2 weeks out from your event, they might be much higher, if not the entire value of the event. And so the timing really matters. And even if you don't cancel your event with some of your vendors, or perhaps a hotel for your event, if it's one where people are traveling, there may be damages if you underperform on your contracted estimate, essentially an attrition penalty. And so that's a fair bit of financial exposure, especially for events that may be coming very soon within the next 2 months. By contrast, there is the contract term typically called force majeure. Occasionally it'll be referred to as impossibility. And that's a clause within the contract that completely excuses performance if there are circumstances outside of the party's control that will prevent or impede the performance. And although most contract terms and most terms in the law that aren't in English come from Latin, this one is actually French, force majeure, and essentially means a superior, a really strong force that has overtaken what the parties agreed to. There's some variations about whether or not this applies only for foreseen or unforeseen events. So typically a force majeure clause will include a list of the events that are definitively covered, and some language either expands or kind of fixes that list. If force majeure does not apply, or if you have a contract that does not have a force majeure clause, there are still common law doctrines of impossibility or frustration of purpose that could apply to give you some relief, although they are very high thresholds to meet. And an interesting thing about this is the force majeure doctrine, as well as those of impossibility and frustration of purpose, they're all state law doctrines, and so they may vary from jurisdiction to jurisdiction, depending upon where your event is located and what governing law you apply to your contract. And the force majeure clauses are easier to enforce if you have them, but they are still very narrowly construed. And so you really have to look at the state law of the relevant jurisdiction to see how to interpret it. Next slide, Paul, please. Because on the next slide, we're going to talk about what the elements of your force majeure clause are to help interpret it. And so as I mentioned before, there's a list of supervening events. This is the list that includes acts of God, strikes, natural disasters. Some force majeure clauses will include a reference to a medical epidemic. Some of them may target them by government pronunciations, so say a pandemic declared by the World Health Organization. Some of them also have as a force majeure event the limitation or formal disruption of travel by government agencies. And so that may include a percentage of attendees whose travel is prevented within the force majeure clause. So for example, it may include if 25% of your attendees cannot arrive due to travel restrictions. That may be considered a force majeure event. There's also typically a catch-all phrase within your clause, something like in any other occurrence beyond the party's control or other emergencies beyond the party's control. How broadly these catch-all phrases are interpreted is also a matter of state law. In many jurisdictions, they're relatively narrow, depending upon the exact phrasing, but they typically follow only the types of events that are listed and ones similar to it, unless the wording is very expansive. The next thing to look for when trying to interpret your force majeure clause is what the standard for excuse is. A kind of historical, typical way to describe a force majeure is it makes performance of your obligations under the contract illegal or impossible. A slightly more modern version is impracticable or even commercially inadvisable. And impracticable and commercially inadvisable are a lot more broad and easier to meet than illegal or impossible. They're still very high. Commercially impracticable has a very high burden. It has to be incredibly expensive and almost inappropriate to undertake from a business end before it's met, but it at least is still easier than impossible, which is often objectively impossible, rather than a way to think of impracticable is objectively impossible. And then there's the operative phrase of what you get if force majeure applies. Classically, force majeure excuses the parties from performance of the contract, meaning you all go back to your original state, you return and refund any monies that have been exchanged. But that's not always true. Sometimes a force majeure clause will only release you from the obligation for future payments, and any prepaid fees or expenses that have already been paid and invoiced to the other party will not be refunded and will still be outstanding. And so you have to look again at the exact precise terms, even though classically a force majeure clause excuses self-performance. And then finally, the last element to look to is the notification requirement. And that may be either in your force majeure clause itself or elsewhere in the contract, talking about notices under the contract. And just like with the insurance claims that Mary was talking about, it's important to follow the precise requirements of your contract in terms of delivery, type of delivery, and to whom that you give notice that you're invoking a force majeure clause. Another thing that may come up in this category is the timing of your force majeure clause notification, because if it's happened as in within 5 days or 10 days from the force majeure event, you have to be careful about what you're calling your force majeure event. And in the COVID-19 case in particular, this is unfolded geographically, and it's been different almost every day and sometimes, during the day. And so deciding what point the force majeure has been enacted is significant, and then you have to start your clock on the timing of the notification from then. Next slide, please, Paul. And so I want to talk a bit about the applicability of force majeure clauses, because as I said, historically, the standard clauses aren't that broadly interpreted by courts. And they might not completely protect you from all the expenses related to your event based on COVID-19 because they're drafted narrowly. And if you have a clause that is really unspecific with regard to the types of events, or is broad but doesn't mention any medical epidemics or other similar events, it may be harder to invoke force majeure in that particular context. As I mentioned, there are ones that are more flexible that include words like inadvisable and commercially impracticable. But as I said, those are high burdens, and so you still may require litigation in order to enforce an invocation of these clauses. And in the current situation, it's hard to say exactly how they will apply and be interpreted. The courts have never interpreted a similar situation with such a wide disruption of business practices due to a medical epidemic. So we don't have a lot of guidance on how strictly and narrowly these will be applied. And then the last point I want to make when thinking about the applicability of force majeure and other cancellation clauses to an upcoming event is to be sure to look at all of your different contracts for the same event, because your contracts with different vendors may have different provisions. And so the convention center contracts that you signed may be different from your exhibitor contracts. Some may allow for refunds, some may not. And so it's important to keep an eye on the big picture. And with that, I think I'm going to turn it over or back to Paul for the next slide.
Great. Yeah, thank you so much. That was very helpful. The next part we're going to talk about, and we're getting near the end of our time, are employment issues. And my partner Jen Brzezinski is going to walk us through some of the numerous employment issues that can arrive in this current environment. So Jen, why don't you go ahead, please?
Sure. Hey, everyone. Paul, the next slide, please. So I thought it would be a good idea to first talk a little bit about the Families First Coronavirus Response Act and the paid leave that certain employers are going to be required to provide paid leave. The reason why this is so important is because the act becomes effective actually this Wednesday, April 1st. So to the extent you haven't thought about it, definitely start thinking about it because some of you might be subject to it. The requirements of the act are going to remain effective throughout the end of the year, December 31st. The first question you're probably all asking is, well, am I covered or not? So the Act covers certain public employers and all private employers, including federal contractors that have less than 500 employees. And for those of you who are kind of on that 500 employee threshold, and you might dip below the 500 or above the 500, know that you're supposed to make the determination at the time that the employee's leave is supposed to be taken. So if you're fluxing in and out of that 500, you're going to have to reassess. And this is a different test that we typically use under the Family and Medical Leave Act to determine whether an employer is covered. When you're making the 500 employee count, you're going to include temp employees who are working, if you have anybody through a staffing agency, and of course, independent contractors are not included in that count. I did want to note that there is a small business exemption for employers with less than 50 employees. However, we don't have a lot of guidance on that. Businesses whose business viability would be affected by the provision of this leave are going to be eligible. But the Department of Labor has said, listen, don't send anything to us asking for the exemption, and we will be having some guidance that's going to be forthcoming with directions with regard to that. So that's the employer coverage. Now let's talk about which employees are covered. Again, this is very different than the Family and Medical Leave Act coverage that we normally deal with. And the answer really depends on the type of emergency leave that the employee is going to be applying for or requesting. So with regard to the emergency paid sick leave, all employees are going to be covered. They don't have to work a particular amount of time for us or have a certain hours requirement. If they're applying for emergency family and medical leave, the employee has to have been on the payroll for at least 30 days prior to the date of the leave that they would begin. So not prior to April 1st, 30 days prior to the date when their leave set to begin. And so as I had indicated, there are two types of paid leave. The first is the emergency paid sick leave. And so an employee is entitled to this leave if they are unable to work or telework, and they are, because they are subject to a federal, state, or local quarantine or isolation order that's related to COVID-19, or if they have been advised by a healthcare provider to self-quarantine due to COVID-19 related concerns, or if they are experiencing symptoms of COVID-19 and they're seeking a medical diagnosis, and if the employee is caring for an individual who is subject to a quarantine or isolation order related to COVID-19, or if that individual that they're providing care to has been advised by a healthcare provider to self-quarantine related to COVID-19 related concerns. So for any of those 5 situations that I mentioned, a full-time employee is going to be eligible for paid sick leave for 2 weeks, up to 80 hours. They're going to get 100% of their pay. However, it's capped. That pay is capped at $511 per day and $5,100 in the aggregate. Part-time employees are going to get a pro rata share of the numbers I just mentioned based upon the hours that they work over a two-week period. Now, if the employee is caring for a son or daughter because their school or daycare is closed or their child care provider is unavailable because of COVID-19 related reasons, a full-time employee who has been on the payroll, like I said, for 30 days, at least 30 days, is going to get up to 12 weeks of emergency family and medical leave. So it's 12 weeks total of this leave. Now, the way this works is the first 2 weeks of this 12-week period is going to be unpaid. However, they do have the employee is going to have a couple of options, and this really is up to the employee. So they can take the first 2 weeks of leave unpaid, or they could use any accrued unused PTO that they have under your policies for those 2 weeks, or they can take emergency paid sick leave for those 2 weeks, but this paid sick leave is going to be payable only at 2/3 of their pay. It's going to be capped at $200 per day and an aggregate of $2,000 total. So that is just for the first 2 weeks. Now, I said it's a total of 12 weeks for this emergency family and medical leave. So the remaining 2 weeks of that 12 period is going to be payable at that last rate that I mentioned. So 2/3 of the employee's pay capped at $200 per day, and that's going to be $10,000 in the aggregate. So the question that I'm getting a lot from contractors is what's the interaction with the other leave that I paid? So what if we have PTO that would cover this situation? Know that this paid leave pursuant to the Family First Corona Response Act is going to be in addition to anything that you already provide your employees. And it's also important to note the employee has the choice as to what type of leave that they want to use, meaning you can't force them to use this emergency paid leave, and you can't force them to use the PTO. It's really within their discretion. So because it's within the employee's discretion as to which type of leave they want to use, and the order they want to use it in, it allows for what we call the stacking of benefits. So essentially, an employee is going to have 2 weeks of the emergency paid sick leave if they haven't used the emergency paid sick leave for the first 2 weeks of the Emergency Family and Medical Leave Act, they're going to get 12 weeks of that leave. And then they're going to, on the end of that, they still can use any PTO that they have under your policy. So it really allows the period of paid leave to be stretched out. You can't run it concurrently like we do with some other types of leave, like short-term disability benefits or parental leave. Please know that there is a posting requirement. I know some of you probably are already working remotely. You're permitted to circulate the notice of this leave, actually electronically. You can go to the Department of Labor's website. They have a poster that you can circulate, and they also have a Q&A section on the posting requirements and how they're satisfied. So the good news about this emergency paid leave that you're going to be providing to your employees is you're going to get the dollar-for-dollar reimbursement through tax credits for these qualifying wages paid under the Act. Now, of course, if you're more generous and decide to give your employees more leave, right, you're going to give them something in addition to what the Act actually provides for. You're not going to be able to reimburse those amounts through the tax credit. And I'll mention, because Paul and Mary also talked about documentation, you can ask for documentation to support for this leave. You definitely want to get it and make sure you're processing all of these requests properly, particularly if you're going to be seeking reimbursement through tax credits. It's not on this slide, but I did want to mention, as Paul had stated at the beginning of the presentation, on Friday, the Corona Aid, Relief, and Economic Security Act, the CARES Act, was passed on Friday. And it does offer relief specifically targeted to federal contractors whose employees can't perform work on site that has been approved by the federal government during a COVID-19 public health emergency due to facility closures, and cannot telework because the employee's job duties cannot be performed remotely. A couple of things to note. This just authorizes federal agencies to use available funds, modify these affected contracts without consideration, but they're able to reimburse paid leave, including sick leave and things like that. There is supposed to be an all-agency memorandum that's supposed to come out shortly to guide contracting agencies on this new provision of the CARES Act. So next slide. Paul, thanks. I'm really at the end of time here. Okay, so office closures, furloughs, and layoffs. So, office closures, if you don't have enough, I'm going to go through this really quickly. If you don't have enough time to keep your employees fully utilized, just know with regard to your exempt employees, if the employee is able and ready and willing and able to work, you're not going to be able to make partial deductions from their salary when no work is available due to an office closure. So if you have some work for these exempt employees to do, you can go ahead and continue to pay them their full salary, but then deduct from their PTO balance for the hours that they don't work. So let's say they work 20 hours a week, you can deduct the remaining, and you have a 40-hour work week, the remaining 20 hours can be deducted from their PTO balance. So that way they're still getting the same salary, but you're just deducting from that PTO balance. That's permissible. Or you can reduce work hours and pay. If this is going to be for a longer term duration, you just need to do that prospectively. When you're reducing employees' hours, both in a furlough situation, which is when you're putting them on an unpaid leave status, you want to make sure to see whether they're still going to be able to be covered under the terms of your health plan. A lot of times they're going to fall below the requisite regular scheduled hours. It's going to trigger COBRA. And both in the furlough and sometimes the partial work week, they're going to be eligible for unemployment. Of course, that varies from state to state. With regard to a layoff situation, it is just a formal separation, of course. You're going to send the last paycheck with any accrued and used paid time off that they're entitled to. CERB is going to be triggered, and then employees are going to file for unemployment insurance. Next slide, please. And then finally, if you go to the layoff situation, be mindful of the Federal WARN Act, and that only applies to you if you have 100 or more employees. You're supposed to give 60 days notice if you have mass layoffs under certain situations. There is the unforeseen business circumstance exception, right? So if you had a reason that you had to shut down, kind of like COVID-19, you can forego that 60-day notice period. However, you still have to go through the WARN process. And even if you're not subject to federal WARN, you still want to check your state laws because a lot of states have mini WARN acts. Although some states like California have actually already waived their state WARN requirements in light of the COVID-19 situation. And I'll turn it back to Paul.
Thanks, Jen. So we are up against our time. The last section was communications. Well, I think slide 56 about really encapsulates that. If you just want to walk through that very quickly, and then we can end.
Sure, absolutely. So basically, this is just to think about when you're communicating with your customers, as Paul and Diz have talked about. You're talking to your employees, as Jen has said, your insurance carrier, the public, your suppliers. It's important to think about how you're talking to different people. Make sure you've got the right message to the right audience. By the same token, make sure you're consistent across audiences so that you don't trip yourself up. Make sure you preserve your rights if you're dealing with insurance carriers or with the government. By the same token, be transparent about where things stand. Consider whether something is covered by privilege. If it's an attorney-client communication, make sure you're limiting your audience so that you're only talking to your attorneys if you need to preserve the privilege on something. And then finally, make sure that it's accurate. That you don't want to be engaging in speculation or sending misinformation out. You want to make sure you're being consistent there. So it all kind of ties together to make sure you're thinking through how everything's being communicated as you deal with all these very complicated underlying issues. Paul?
Great, thank you. So we actually have run out of time for questions. There are a couple questions that came in. We will answer them to you directly in the next 24 hours and ensure that you have that. I'm thankful again for the panel for taking time out of their day to participate in this. I thought it was a good discussion, and we certainly appreciate all of you that have given up 90 minutes of your day to attend this. And I hope that we get through this quickly, and I hope that you all be well. Take care.